All right. All right. Well, that was an adventure. I don't know what the hell happened. It took like several reboots. I tried different mics. Nothing was working. So I think we are back now. And so the let's start this over. Oh my gosh, what a nightmare. Sorry guys. I appreciate those of you that stuck around because that was super duper frustrating. Which way am I going? All right, got to get back in position. Okay. Wow. So there goes my funny ass intro because instead I decided to fill it with what 20 minutes of dead air. So I have to trim that later. But let's just get right into it. So previously we mentioned that, in fact, we've probably been through this now. What is it, 4 or 5 times? ThinkUp files a lawsuit against Tastemakers and Disruptive Products Inc., the parent company of Tastemakers, who, of course, is our beloved company that runs Arcade1up or owns Arcade1up. And um, uh, so, is there something wrong with the volume now? I saw some volumes add fart noises. Okay, well, hopefully you guys are just behind. You'll let me know if there's a volume problem because it seemed okay. Um, all my measurements sounded okay. Awesome. Okay. So we mentioned we've been through this time and again. ThinkUp files a lawsuit against Disruptive. It goes for a little bit, then it gets dismissed either at the behest of ThinkUp or because it was filed in the wrong jurisdiction, right? Number one, file pulled back. Number two, wrong jurisdiction. Number three, pulled back voluntarily. And then here we are. They filed number four. This lawsuit came late in October. So almost immediately after they voluntarily dismissed the last lawsuit. So you've got to hand it to them. They really want to stick with it. And so let me bring back up the documents here. And let's see. Give me 1 second. I was prepared, I swear. Okay, so here's their new filing, and I'm going to spare you reading this entire thing because, as you will see, it is basically identical. These are just the summons. One is to ThinkUp. The other one is to, or sorry, one is to Tastemakers. The other one is to Disruptive Products Inc. Of course, ThinkUp appears here with their attorneys, and they allege basically the exact same claims, right? That they designed the Arcade1up shark fin design. They designed the risers. They designed the Infinity game table, and they allege that they are owed royalties of 3% on the designs of those products, so 3% of sales. They allege that ThinkUp did not provide adequate accounting of sales, and they allege that the royalties, even if the agreement were to be terminated, that the royalties would continue on for the life of the product, and that the only products they would not receive royalties on are those that were not completely, the design had not been completed by the time that the lawsuit was, or at the time the agreement was terminated. So all the same allegations. What they've done in this filing is clean up a little thing, and I have to hand it to them. This one's done a little better. Again, 90% of this is exactly the same. But when you get into some of this, the wording, the reasoning behind the breach of contract claims, uh, some of the other issues like that are a little more uh, balanced. They've got more teeth behind them. You see this royalties for each of the, I think, or products, blah, blah, blah. So not going to go too much into this because we've been over this one ad nauseum because again, it is basically the same claim. But what I can tell you is I've read through this and they did make better arguments, slightly better arguments, right? Like they've actually called out royalties for a game like Pac-Man. But look, I see a typo here already. Arcade1up. All right. So this one is the agreement confirms the permanency of the royalties it provides at termination. ThinkUp will continue to receive commissions on all Arcade1up machines which have been completed. However, it will not be entitled to commissions on machines that are in the development stage and not completed at the time of termination. So this again is the provision they're saying, look, we had agreed that the royalties would be for life, and this provision in the agreement, which we've also shared the agreement before, specifically aligns to that. And it goes on, here's the royalties. But then they say, hey, in this other one, now you're saying when you terminate the agreement, um, uh, it's inconsistent with the statement above that says they get royalties on any product that had been completed and developed. And they're saying now down here, for some reason, you're saying all such commissions on orders shipped within 60 days of the order date. But what now, this is where their argument changes a bit and gets better defined. They say what this paragraph does not say is significant. And so let's read that paragraph. It says developers shall be entitled to the commissions in accordance with the provisions of this agreement on orders written up to the effective date of termination or expiration or such other length of time as agreed in writing by the company and developer. All such commissions on orders shipped within 60 days of the order date shall be considered earned in accordance with this foregoing and shall be paid in accordance with the provisions set forth below. So again, what ThinkUp argues here is that it does not say that the developer will not receive royalties or commissions for sales of Arcade1up machines after termination. It does not use any limiting phrases such as only up to. Moreover, at best, the inconsistency of this paragraph with those cited above creates an ambiguity that can only be resolved by the omission of the prior written and oral statements providing for royalties for life. So this is how their argument has changed just a bit. They've pointed out that even in the contract itself, it's not definitive that they don't get those royalties forever. They use the provision above that says, hey, the royalties are paid for 3% on any product that has been completed. And then down here, it doesn't say you're not going to get any future. It just says you will get paid for things at within 60 days or in accordance with what we've agreed to in this agreement. So they're alleging now that this agreement would still, even though it's been terminated for future things, should still be paying them the 3% commission. So that's the gist of where they've changed their argument. Everything else they allege has remained exactly the same. So let's fast forward a bit, right? So we have our same kind of what happened here? Anyway, so one of the documents is missing, but I did download. All that was the agreement itself, which we've been to. These are some of the essentially the letters. This is the initial termination of the agreement. We've talked about these financials before. Nothing new in the financials department. It's the same stuff from back then. Then you have here's the termination of the agreement. We've talked about this letter before. So if you guys are tuning in for the first time, just catching up, we've gone in depth into these in prior videos, so you can jump back and look to those. I'm not going to spend a lot of time here. There's a lot of provisions of these agreements that kind of really put ThinkUp in a bad position in their argument. But now they're, as a result of pulling the past lawsuits, filing this new one where they revised that, they've changed their argument a little bit, which helps them out here in this spot. And it looks like we've got a $9.99 super chat from NASA Canes fan. Appreciate that. And he says, what are we on? Strike number 4. And yeah, we're like at strike 4 or 5 at this point. So anyway, so getting back to this, you can read that agreement. It's very interesting, especially the financial aspects and how many they're selling. So like I said, we've covered that. You have the letter that terminated the agreement. You have these letters that are like, here's your final payment. We need you to release your rights, which obviously ThinkUp refused to do. Then we start getting into um, the responses, right? And almost immediately, sorry for scrolling around here, but almost immediately upon filing on December 3rd, so about 30 days after the case is filed, both ThinkUp and Disruptive move immediately to dismiss the case. And in their motion, basically, they're arguing. You can see there's a whole lot of court cases here, so I'm not going to go through this at all. But basically, they're saying, look, this company has filed this suit on 4 other occasions. All were dismissed. And so we think this case should be dismissed immediately. They point out other case law that says, hey, in similar cases like this, the courts have ruled in the defendant's favor, so just might as well dismiss it now, because those courts found that they had an agreement and there's therefore nothing they can do about it. And essentially, they make that argument. And then, of course, as to be expected, uh, the response of the other company, so between between Tastemakers and Disruptive, both file motions to dismiss. The language, the cases are almost identical. Then they both affirm each other's motion to dismiss, saying, yes, we agree with that. So the judge provides a time frame in which the plaintiff, ThinkUp, has to respond to Tastemakers and Disruptive's motions to dismiss. So this is normal procedural stuff. And so the court sets a date of December 10th. And, it's holiday time, things like that. So naturally, ThinkUp's attorneys respond and say, hey, it's the holidays. We would like an extension. Can you give us an extension to file our objections to their motions? And the court says, yeah, you're busy. It's the holidays. Of course, we'll grant the extension. So the deadline to file a response to the motion to dismiss is extended to December 20th, I believe. Well, December 20th comes and goes. Let's see which one. Where are we on this one? Let me make sure I'm trying to find the okay, yeah. So so that's what this is. So the date comes and goes, and then on January 10th, which is another 10 days after the deadline, Disruptive and ThinkUp come back and say they missed the deadline. ThinkUp didn't respond with their objections by the 20th. So we move that you dismiss this case immediately with prejudice because the plaintiff didn't follow your order. And here's all the reasons why that should be dismissed. And that is exactly what the judge did on what date was this? January 13th. So 3 days later, the following e-file documents, blah, 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 read motion to dismiss, motion for dismissal. And those are the 2 different ones filed by Tastemakers and Disruptive. And it says quite clearly, it is ordered that defendants' motions to dismiss are granted without opposition, and the clerk is directed to enter judgment dismissing the complaint with prejudice. So the judge moves, case is gone, and it's with prejudice, meaning ThinkUp cannot refile their lawsuit. So boom, it ends right there, right? Well, not so fast. While it does seem to end, it of course doesn't, because as you guys know, all is fair in love and war. So immediately they come back, and ThinkUp's attorneys said, hey, we screwed up, judge. Our clerk thought she filed it. She never got a confirmation. We were all done in time. We were ready to go, but she didn't file it correctly. We're sorry. We're sorry. Please understand it was really busy. It was around the holidays. It was just a poor mistake. And then, that employee uh, signs an affidavit swearing to the mistake. Then ThinkUp, their attorney files an affidavit saying swearing to the mistake. And so naturally they file that motion to have the motion to dismiss vacated. And then we get some more back and forth. We get Tastemakers jumping in and Disruptive jumping in, filing more motions to object to the motion to vacate the order, arguing this, that, and the other, saying, hey, you already ruled. They filed this case 4 times already. This is how many times do they get to file the same case and allege the same arguments? And then ThinkUp's lawyers once again file, and they reply back with the response to the motions. And they say, look, it was an honest mistake. We think the case should be moved forward. It should be heard on its merits. All the other cases that these attorneys are bringing up, they are all cases that were heard after evidentiary hearings. And so the rulings in those cases never came at this early stage before any evidence has been heard. So we think you need to vacate the order. It was an honest mistake. Here's the law that says you should vacate the order. And so the judge considers it, and the judge does just that. She vacates the order and reinstates the case. So that's really where ThinkUp almost harpooned their own case, right? They went in there and didn't file paperwork on time and almost blew the whole thing up. It got dismissed with prejudice because they didn't do the job. And it's again, this is not legal advice, as we like to say around here. I'm not an attorney. I just play one on YouTube. All of this is for entertainment purposes. So these are all just opinions. But man, oh man, like how many times can this one law firm make mistakes? Whether it was calling the CEO of ThinkUp by the wrong name, completely messing up some of the arguments, filing it in the wrong jurisdiction. And now here we are with missing key deadlines that's set by the court. It's a comedy of errors, of self-inflicted wounds. But luckily for them, the law was behind their side, and the judge has reinstated the case. So now we've moved forward. We have some very recent filings as a result of it being reinstated. These came in. This is the judge reinstating. It is ordered that plaintiff's motion is granted to the extent that the January 13th orders are vacated. The action is restored. Blah blah blah. So we've received now response from both ThinkUp and not ThinkUp, Tastemakers. It's too many companies involved in this case. Tastemakers and Disruptive Products Inc. Objecting to now the original argument. So we've actually now progressed further than we have in any of the other cases, I think. This is at the point where we've seen this case kind of go quiet, and then we get the voluntarily removal, or we get the we've got the motion to dismiss based on jurisdiction in the Jersey case. So now they've made real arguments as to why they think this case should be dismissed. And so now we're just kind of waiting at this point. So long story short, we've refiled, and now we're actually closer to getting some info. So we'll see if it makes it past this preliminary stage. And I tend to believe their new argument holds more water when they talk about the ambiguity in the contract, because the law around that in the state of New York, the laws that are being referenced are very clear, point to that inconsistency as needing to be determined in a courtroom, that there is nothing definitive, like as noted by their attorney, the lack of terminating language saying like no further payments will be due, etc. no time capsule is going to be important. And so I think we might get a little closer. Anything can happen, but I do think it may survive this preliminary stages, and we may see this move to discovery now. Certainly a better argument than they've had so far. Um, hopefully their attorneys will stop committing self-inflicted wounds. But um, it's interesting. So, what does this actually mean? Not a whole lot at this stage. I mean, the case is back on. I mean, that's the important thing. The you know, will it potentially have overarching effects for all of us, the consumers? Are we going to get more products? Are we not going to get more products as a result of this? Is there desperation in Arcade1up? That we will see. I certainly know we've gotten a lot of good information from behind the scenes at Arcade1up as a result of this case. And if it does go to discovery, uh, we may get more. However, I would imagine that at that point, if they are forced to provide an accounting as part of this case, they'll probably move to have that portion of the case sealed if they're paying attention, so that it doesn't get out there what they've sold of actual units. But it's hard to say. And so it's important to know that ThinkUp's case lives on, and there is a glimmer of hope for them. So that's really the big update. It wasn't going to take too long. Unfortunately, I'm a little discombobulated from all the technical problems going live today. So I apologize for that. Thank everybody for sticking around. And thanks, NASA Canes, for that $10 super chat. Your patience is much appreciated. So very interesting. Yeah, of course they did send. Oftentimes they do those things in certified mail, but many things are electronic now. So when the notifications go to attorneys to attorney, they often waive the certified mail summons, and it just happens to go through an electronic system. In this case, those probably were sent certified. Obviously, ThinkUp knew the deadline. They agreed to the deadline. They still missed it, but as they stated under penalty of perjury, it was just a mistake that they did. They thought they filed and did not get the confirmation. Um, Trying to go through some of you guys' comments because I was just trying to get through that. I didn't want to sit and read lots of legal documents we've been through already. We have Josh McKinley says, so is this what Iconic Arcade is going through with Street Fighter, where it is? That's why the pre-order button on the site is removed. So excellent question, Josh McKinley. So this is an actual legal lawsuit. So this is all matter of public record. You can look at this. So we've heard rumors, and it's just a rumor. There's been no confirmation. I've attempted contacting all companies involved, including parent companies and other, formally for a request for comment in order to try to confirm those rumors. There is no confirmation. So as far as we're concerned, it's totally a rumor and not really worth reporting on until we can confirm it. But the rumor, obviously, it was talked about on another show, is claiming that Iconic Arcade and potentially Media 1UP, John D's company, received a cease and desist. That cease and desist could be for a variety of reasons. They could allege patent infringement. They could allege unfair competition, tortious interference. There's all kinds of things they could be alleging in their copyright infringement. It's hard to say. Like, we don't, if it even if it even exists, we don't know what's being alleged in it. And it's just a cease and desist letter. That's just a formal way for a company to go on record with another company or individual saying, we believe you've infringed our rights. Any claim in a cease and desist is not under law. It's not legally binding. It is just somebody physically stating, hey, I think you doing this. Stop doing it, please. And the company or persons receiving a cease and desist, can they choose to address it or ignore it, right? If they legitimately feel reading the a cease and desist letter. Again, this is all hypothetical because we don't know that even one has been received. But theoretically, you review it, you decide whether you believe it you did inadvertently or or purposely violate one of those issues, then you have to address those. If it's completely baseless, you may check with your attorneys just to confirm, and then you just ignore it and move on. A cease and desist is typically a precursor for a lawsuit, but oftentimes and more often than not, cease and desists are just there to scare somebody, and they don't go on from there. So again, I'm not going to comment on whether Iconic Arcade received one. I've heard the rumor, but I have no facts that that's true. And if I were another channel, I wouldn't want to be going live with the rumor unless I knew it to be true. But that's up to them, because you go around spreading rumors like that, you can find yourself at the end of a lawsuit. So uh, you know, good for them, I guess. But like I said, it's rumor, it's unconfirmed. Uh, that's all there is to that one. But so yeah, and if they did receive some sort of uh, cease and desist, you got to remember that Iconic Arcade is a European company. I think this may be the first time they're operating in America, so there may be some, extra level of diligence. But again, I don't even know that they've received one. That's just all rumorness, right? Anybody can start a rumor. It could have been just made up by that person and started spreading, or made up by somebody else who made it up to trick that person. I have no idea. We have no idea. And until something is confirmed, it's just reckless to go around and talk about it. It affects the bottom lines of two companies, the employees involved in those companies. Until there are facts to be talked about, it shouldn't even be talked about it. So that's all I'm going to say on it. It's, people can keep asking about it. I'm going to say the exact same thing in that regard. Until there's evidence, it's just rumor mill nonsense. Um, but what we're here for is the ThinkUp thing. And if and when there's a lawsuit around the other thing, you bet we'll report on it, because I, find those things interesting and I think they're newsworthy. But again, all this stuff is just opinions. Not to be taken as legal advice. You should always consult an actual attorney for information. Yada 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 yada. Um, so there's that. And as far as the pre-orders of Iconic Arcade go, yeah, the link is broken on the site, but you can still go to the same website where you placed pre-orders, and there's the pre-orders can still be placed. So it's not like it's been taken down. The product is still live on Iconic Arcade's website. You can go see it there. It's just the link to VMI isn't working, but you can go direct to VMI and you can continue pre-ordering, whether in the US, Canada, or wherever. So it's not like anything's been taken down. And we should also point out, you had the announcement by Arc Systems of two other cabs, right? Just like last week. So, who knows? But there's that. So let's see, anything else? I don't know. Just guess Street Fighter 2 XXL pre-orders are down to, so they're, again, that's the rumor, right? But they're actually not down. You just can't click the link through Iconic Arcade's website. You can go direct to the place that was actually taking the pre-orders and pre-order them there. It's as simple as a Google search, though I know many other people have been reporting on that link issue for a couple weeks, so it hasn't been fixed. But they all have the direct links to the pre-orders. I think Cornercade covered it. Michael B covered it in regards to the Canada pre-orders. I don't know who else covered it, but that has been an issue for several weeks at this point. And it could be anything from just who knows what, right? Could be a technical issue. It could be a desire to slow down on the pre-orders. I don't know what. Could be anything. Could be related to the rumors. I do not know. So, and it looks like Danny put the pre-order links in the chat. Retrolert said A1up did not become the fourth largest brand in gaming for nothing. Yes, and ThinkUp wisely uses that to their advantage throughout the lawsuit. Very interesting. Um, End of the line says it's weird that VMI website is still active, though. Yeah, I mean they're still taking pre-orders because it's still an active product, right? It hasn't been pulled. They're well aware of the broken link, but it's been weeks and it's not been fixed. Absolutely. Uh, uh, hopefully it didn't cause damage. Oh yeah, the plumbing. Yeah, that sucks. It's all baloney. That's like saying McDonald's suing Burger King for them copywriting a hamburger. A1Up has no claim to the home arcade scene. Why didn't they go after iArcade then? Yeah, that's exactly right. Um, so yes, that was quite a while, Michael B. Quite a while ago. Um, I'm not going to make that claim. Anybody can sue anybody for any reason at any time. Doesn't mean you actually have a case. And obviously, it would be bad PR for any company to do that. so, so I wouldn't recommend it. But it depends. I wouldn't stick your foot in your mouth without evidence. That's all I'll say because anybody can sue anybody for any reason. Uh, Appreciate that, MG. So I already wasted 20 minutes of your guys' time trying to figure out whatever the heck went on with my stream. And excellent point there, Fox. And so I appreciate you guys sticking. I wanted to keep this to a half hour. So that's about where we're at after I delete the 20 minutes of complete dead air and hope you guys were able to entertain yourselves and have fun. But there you go. So the gist of it is the case was refiled. It was motioned to dismiss. ThinkUp missed the deadline to object to the motion. The motion was granted. ThinkUp apologized, said they had a technical or human error in their a miss of the objection. They refiled the objection and asked a new motion for the dismissal of the order to vacate. That was granted. Now we've proceeded on and official motions to object to the or motions to dismiss the case based on the merits of the case have been submitted by both ThinkUp and um, I keep saying ThinkUp by both Tastemakers and Disruptive, and ThinkUp has objected to those motions based on the case law and that says it's premature to dismiss at this case because of the ambiguity of the contract. You need to take the case into evidentiary hearings so that we can get to the facts and the meat of the case to determine whether it should be dismissed or not. So it'll be interesting. And in my unprofessional opinion, I think we may see this one actually continue on from there for the first time. And so we'll see what happens. I would expect we get some updates to this in the next 30 days. So I'll be watching to see if we get anything. I would expect either a denial of that motion or the granting of that motion to happen relatively quickly since both parties have had their um objections and affirmations filed, so that we should schedule a hearing and then find out what goes from there. So um, if and when that happens, I will update you guys. And again, apologies. I can't apologize enough for the technical problems. I should have tested the audio before I clicked the button because something was hosed up on my computer. But as always, really appreciate you. Uh, if you have mercy in you, you might consider clicking the like button. If you're new here, you click subscribe, ring the bell for notification. We don't always cover court stuff, but when we do, we try not to screw it up for the first 20 minutes and get all discombobulated. But it's an interesting case study to watch these home arcade companies fight it out in their as they dwindle into whatever it is, their implosion or complete shift in business strategy. And I, for one, am enjoying the slow motion train wreck. So until next time, have fun.